Hello, thank you for coming to my paper. It's a bit of a strange way to give a paper. It's nice not to have any sort of conference hangover. Not that I ever give a paper with a hangover. But yes, I'm very much looking forward to your comments and questions afterwards. So, in this paper, I'm going to talk about the role of love in the interpretation of human rights in the UK. So, under the Human Rights Act, UK courts have, I think, largely departed from the duty and property-based concept of love that previously shaped the law. Instead, they've recognised and applied an idea of love grounded in our ability to choose how to live and who to love. However, I'm going to argue that the courts have not yet felt able to give full protection to this modern understanding of love, and have shown deference to the government and its restrictions upon relationships, which reflect a pre-modern idea of love grounded in duty and the value of property. So what is love? Well, luckily, for as long as humans have been writing, and probably for a long time before when they were sitting around the fire, humans have been trying to define love. And across all these different definitions, across the centuries, two elements seem to be common for everything from Plato to the present day. First is a desire for togetherness, okay? And the second, this desire for togetherness affirms the identity of the lover and the beloved. So this first element, the desire for togetherness with others, is a constant across all definitions of love. It is a fundamental part of the nature of human beings as social beings. And Bowlby, in his research, suggests it's one of our strongest and earliest instincts, and it's important from a survival perspective, that we want to be together with other humans. The second element, however, this affirmation of the identity of the lover and the beloved, this distinguishes the desire for togetherness as love from other desires for togetherness, such as ownership or possession. Okay, and it also distinguishes the different ideas of love, or different sort of theories of love. And this is because what is recognised as love and who we love involves an element of judgment. Well, it involves a judgment of value. Okay, so this desire for togetherness, okay, this affirmation of the identity of the lover and the beloved, okay, that involves a judgment of value about the identity of the person that you love. At an individual level, this is influenced by our own identities and different life histories. In the terms of different theories of what should be recognised as love, each theory has an underlying moral judgment about what desire affirms the nature of the individual and the beloved. Okay, and this leads Martha Nussbaum to describe love as a moral judgment. The major distinction between concepts of love that I think is present in the modern day is between love seen as grounded in a morality which values individual obedience to moral duty and derives from a historical Christian morality, and the sort of modern idea of love as grounded in the freedom of the individual to choose how to live, and that sort of freedom of choice which underlies the sort of global model of human rights more in modern times. Okay, so we have these different ideas of love. So we have desire for togetherness, which affirms the nature of each, okay, and then different ideas of love underpinned by what we value and what we value in the other and desire for togetherness with or recognise as love. Okay, so prior to the Human Rights Act, historically English law and family relationships has strongly been characterised by valuing duties and property. Okay, so John Eclair argues that so English law and family relationships was directly premised on securing adherence to the social order and protecting property. And we can see this in various laws which continued until very recently, showing this strong influence of duty and property. So we have the doctrine of legal unity, okay, which gave men control within marriage. That was not fully abolished until 1982. The duty of consortium of husband and wives to live together, and of the wife to care for the husband, and the husband to support the wife, was only declared defunct in 2010. And the requirement to prove fault in divorce, okay, breach of marital duties, that was only abolished in 2020. So yeah, you see this idea of duty and the protection of property, control of property, as sort of vital, or as the underlying principles behind the recognition of relationships and the protection of relationships within UK law until very recently. Yes, consent to marriage has been required since the 12th century. But McFarlane argues that the prevailing social pressures and morality, okay, this background morality of duty, in reality made it the duty of children to gain parental consent for their marriages. Okay, so that's the sort of background context. Well, where are we now? Okay, so love in the time of human rights. So under the Human Rights Act, the courts have increasingly departed from the law's historical approach to relationships. The courts have been increasingly willing to use the Human Rights Act to give recognition to individuals' choices of relationship. Okay, so their choice to manifest their relationships, to recognise their relationships in the law. However, the historical duty and property conceptions of relationship, of love underpinning these, continue to exist and influence our society and therefore within our law. And this has limited the amount of protection the courts have been prepared to give to this modern understanding of love, protecting individuals' choices to manifest their relationships and choose who to love. So the first Human Rights Act case requiring engagement with ideas of love is Gaiden versus Gordon Mendoza. So here the issue is whether a statute which allowed husband and wife to succeed to a protected tenancy applied to same-sex couples. And the House of Lords held that an interpretation of which didn't allow them to succeed to the tenancy violated Articles 8 and 14 of the European Convention. And here we see the court sort of giving quite strong protection to relationships. So Lord Nichols applies the togetherness element of relationships, okay? He recognises the importance of a shared life, shared identity. Okay, so yeah, you can really see ideas of love influencing the judgments here. And Baroness Hale, in her judgment, she cites the basis of the European Court of Human Rights in protecting individual choices as to how to live and who to love. And the majority also rejects Lord Millett's dissent, where he interpreted the Act here, which was passed in the 1920s. So he dissents and said, no, this Act is about protecting interests in property, not relationships. And the majority say, no, it's not about that. What we have to protect under the Human Rights Act is individual relationships and choices of who to love. So yeah, great. Then the next case in relationships is M versus Secretary of State for Work and Pensions. And this involved a challenge to a lack of recognition for same-sex relationships in calculating child support. So if you're in a same-sex relationship, you would have to pay your ex-partner a greater amount of child support than if you were in a different sex relationship. The majority held, however, that Article 8 was not engaged. Okay? And the majority in the House of Lords, based their decision on the facts that by the time the case came to them, the law had been changed, and there was no criminalisation, no threats or humiliation to the claimant. And said, okay, no, your Article 8 rights are not engaged here. And Baroness Hale, okay, she dissents, okay? You can see the majority here taking a sort of property-based look at things almost. And yeah, they are talking about sort of, they're looking for, has there been any tangible harm? Okay? Whereas Baroness Hale, she dissents and says, well, we're not giving the recognition to relationship here that we gave in Gaiden, okay? So, yeah, and she's sort of arguing that actually the recognition of the relationship itself has its own importance, okay? So yeah, we see the step back in M versus Secretary of State and the continuing influence of this property conception of relationships, and not giving recognition to the relationship itself. However, we see the courts have moved on a bit from this, and they are now, I think, quite willing to give recognition to relationships. as we'll see, they're not always willing to protect relationships, but they are willing to give recognition to relationships grounded in this idea of respecting individuals' abilities to choose how to live. We see this in Steinfeld and Kuyden. So here the court held that the lack of recognition for relationships between different sex couples outside of marriage violated Articles 8 and 14. Even though this lack of recognition didn't cause any of the tangible harm that led the court in M not to find that there was a violation. Okay, the Court of Appeal and the Supreme Court held that Article 8 imposed a positive obligation to recognise relationships as an important facet of individuals' identity and existence. Okay, so yeah, much stronger recognition for relationships. Okay, so yeah, the courts are quite good at that. Okay, however, although they're very good at recognising relationships now, I think, within the law, the old sort of ideas of relationships, grounded in the importance of duty and property, have limited the ability of the courts to give protection to relationships. Okay, so and we see this to some extent in Owens versus Owens, and very much so in the other case on the application of Lebanon versus Secretary of State for the Home Department. So in Owens versus Owens, the claimants were unsuccessful in arguing that a loss of desire to remain married should be sufficient grounds for divorce. The courts felt constitutionally incapable of departing from the old property and duty conceptions of relationships here, okay, which required some sort of breach of duty for divorce to be granted. The court recognised that society had changed, but they said the Matrimonial Causes Act was too clear and this change has to be brought about by Parliament. And that was done in the Divorce, Dissolution and Separation Act in 2020. Okay, so understandable. However, on the application of Lebanon versus Secretary of State for the Home Department, okay, I think this actually shows the continuing influence of the duty and property-based approach to relationships in UK law. In this case, the court gave a deferential refusal to give protection to the importance of love to human beings. Okay, so this case concerned the minimum income requirement, okay, which requires that a UK citizen earn $18,600 plus extra for children to bring their non-UK partner to the UK to live with them. Okay, and Lord Conrath and Lady Hale gave the judgment in this case. They recognised that the rule engaged Article 8, but held that deference must be given to the Secretary of State's decision making responsibility here. Okay, so they had found that the minimum income requirement's interference with Article 8 was justified. Okay, but in doing so, okay, they gave no weight. The Supreme Court gave no weight to the importance of relationship. They conducted no balancing in the proportionality in assessment. The court did not balance the importance of relationship against the view that tax revenue should not be spent on non-UK partners or integration. In its approach, the Supreme Court acted in accordance with a pre-human rights understanding of love and of the citizen. Okay, so the choices of the citizen here of who to love were given no weight by the court, none at all. Okay, the Supreme Court accepted this because of deference, but, and I quote, with no doubt. And I would say that this approach echoes the 14th century law on manorial tenants. Okay, whereas if you're a manorial tenant, a serf, you had to pay a fine in order to get your lord's permission for who to marry. Okay, and so the minimum income requirement and the court's deference here is consistent with a pre-human rights conception of love, okay, which gives little place to choice, and it also gives effect to a pre-human rights idea of the citizen, okay, as someone defined as a bearer of duties, not as having a right to choose how to live. And under this approach, in this case, we see only the citizen who fulfills their duty to be economically productive is allowed to have their freedom of choice protected. So, our understanding of love and a legal recognition and protection of it reflect the moral principles of our society. Under the Human Rights Act, the courts have contributed to recognising a departure from the law's previous understanding of love as defined by the values of duty and property. And the courts have moved towards an idea of love, protecting an idea of love as a desire for togetherness which affirms the capacity of choice of the lover and the beloved. However, shows that the underpinning morality of our society is still influenced by a view of individuals as primarily owing duties to the state to pursue financial wealth and not as free to choose who to love. Thank you very much. I look forward to your questions.